Okay, good morning, everyone. I will now call the case, which I've styled in the matter of notice of violation, order of compliance, administrative penalty, order SW 09-2014 that was issued to Watts Webcore Obayashi AJB on April 11, 2014. The date is now June 24th, 2014. The time is now 9 a.m. My name is Monty May. I'm an Assistant Attorney General with the Office of the Attorney General. And by letter dated June the 4th, 2014, the Chairman of the Board of Directors, the Guam Environmental Protection Agency, appointed me Administrative Law Judge. Present is Mr. John Basaski, legal counsel for Watts Webcore Obayashi, which by a notice of appeal, of intent to appeal dated March 21, 2014, requested this hearing and attached a letter dated April 24th, addressed to the Guam Environmental Protection Board of Directors, which alleged new matters in its defense. The notice of violation, the notice of intent to appeal with its attachment, and the appoint letter will be submitted into the record. This letter appoints me as Administrative Law Judge, but I am interpreting it as an appointment as what we call a hearing officer under the Guam Administrative Law. Section 9221 of that says the appointing agency, which is GEPA, may hear a case with a hearing officer, or the agency may direct that the hearing officer sit alone, hear the case, and possess all powers relating to the conduct of the hearing. The appointment letter authorizes me to render a final judgment, but under the law, it appears that I will only prepare a proposed decision for the GEPA board. Under section 9230, the hearing officer prepares a proposed decision that is filed with the agency as a public record. It will contain a finding of facts, conclusions of law, and an order. The board of directors then has a number of options. I could go into them if you request, but your legal counsel can advise you what they are. This hearing will proceed in the manner of a trial. The agency has the burden of proof of the facts by a preponderance of the evidence. Its witnesses may be cross-examined, and evidence from the respondent, which I'll call Watts Webcore Obayashi, the respondent, will not be heard until the agency has stated that it rests its case in chief. I guess you'll be representing the GEPA, Mr. Palacios?
Actually, Your Honor, if I could, it's my understanding that today's hearing, we would not be hearing the merits of the case, and that instead the hearing would be scheduled at some point in the very near future. And that's the guidance that I got from our board last week during our regular monthly meeting. And so we weren't expecting to actually go into witnesses and again, the merits of the case today. More like a scheduling type of conference, if you will, is what I was made to understand.
Okay. Mr. Basaski.
Yes, well, I guess I would just point out that the notice of hearing, I believe, does specify that this is a hearing on the merits. I just have to pull it up to make sure. But I mean, it talks about, procuring witnesses and presenting the evidence, and that the purpose of the hearing will be to determine the merits of the accusation. So, yeah, and then one of our witnesses is only here for a limited time. He's from Hawaii, and he extended till today in order to be able to attend this hearing. And so he won't be able to just stay on island indefinitely to be able to testify, so I would request that we go forward on the merits today.
Oh, do you have a departure date?
You have a departure date?
Tomorrow morning.
It was yesterday originally?
It was today.
It was today.
All right. And you didn't see the notice of hearing I sent to Ms. Benito Sorino? Did you read that?
The notice of hearing?
Yes. Did you? He said the notice of hearing said that the hearing would be for the purpose would be to hear the
Yes.
accusation, the merits of the accusation, and
Yes.
the remedy that EPA request. So Mr. Blasowski is correct. The hearing officer thought it would be for the purpose of taking testimonies, and plus we have one witness who's leaves tomorrow. So it would be best if we had it today. Is that not possible?
Before I answer that, can I just request for a very quick recess? 3 minutes tops.
Okay, we'll
Is that
take
okay?
5 minutes.
Okay,
Okay.
okay, thank you.
We're back on the record now, 9:12 a.m. Mr. Palacios, do you have any plan or request?
Okay, yes, Your Honor. We're going to proceed as stated in your order, and we'll hear the merits of the case.
Okay. We'll see how it goes. Let me see. Who will the witnesses be, if you know, for the keeping?
Okay, well, witnesses, but also part of our team will be Mr. Don Canata, Michael Mallon.
Okay.
Vincent Pereira.
And Vince Pereira.
Is that all that you anticipate for the entire case?
Yes.
Okay. And who will the witnesses be for the respondent?
Richard Maris, David Yates, and
Alex
Miller.
Alex
Miller.
M-I-D-D.
M-I-L-L.
Oh, Mill.
Miller.
Is that all?
Yeah.
So there's 3 witnesses, or 6 total witnesses. Do you have either of you have a sense of how long it will take? Could we do it in one session? Or do you think we have to do another day?
I think I could get through my witnesses in an hour or less. Not
Okay.
sure about, cross-examination of
And
questions.
if we don't finish by lunch, we can break and come back and finish this afternoon?
Sure.
Okay, the exhibits, the agency exhibits will be given Arabic numerals, and respondents' exhibits will be identified with uppercase letters.
Well,
Do you have-
that's no problem. I did pre-mark mine, and they are marked with numbers. 1,
Okay,
2, 3.
we'll reverse
If
that.
that's okay.
Uppercase exhibit A, exhibit B, if there's any need to introduce something. Okay, well, there's something I overlooked which could come up later. This is a special hearing, and it's not clear that the open government law requires public notice, but it was done, and I have proof here that notice was given on the 17th, and the following Friday, the 20th, in the PDM, and requests were sent by email to not only the PDM, but the Memorial Variety, and looks like 5 radio stations for a public announcement. So, do you have any problem with compliance with the open government law, or did you want to?
No objection.
There's, okay, that being accepted, then Mr. Palacios, who is, let me see, your first witness.
Our first witness will be Mr. Vince Wright, Your Honor.
Okay. Yeah, you can call me, well, I guess, Mr. Hearing Officer,
Okay.
but I have been told, and, or Mr. May, or Your Honor, one of those three.
Okay.
Okay. Let's see, Mr. Ferrara, would you raise your right hand, please? Do you solemnly swear or affirm that you will tell the truth, the whole truth, and nothing but the truth in this matter?
Yes, I do.
Okay. Please state your name and occupation.
My name is Vincent J. Ferrara. I'm the program manager for the Hazardous Waste Management Program and the acting program manager for the air pollution program.
Okay.
Also.
So I take it you have some personal knowledge upon the accusations that are contained in the notice of violation?
Yes, sir.
Okay. So we don't have an attorney here asking questions. And so I'm going to just ask you to begin with, at the beginning, give relevant testimony, and we'll see how it goes.
Also, to let you know, there's 4 violations that we listed on the notice against WWO. The first violation is from the regulation is section 1412(9)G that states that the owner shall notify the administrator in writing of the anticipated date of initial startup for each emission unit of a new pollution emission source or significant modification not more than 60 days or less than 30 days prior to such date. That notice was never received by Guam EPA, or there was never a notice submitted by WWO or the Navy telling us that they were going to operate the units. Unless WWO can assert or show us a document stating that Guam EPA was notified with a stamped receipt, then this is a violation that is really there. We never received any letter from WWO or the Navy that they're going to start up the unit. Therefore, they started up the unit without notification to Guam EPA or Guam EPA notifying them that we did receive the letter and we authorized them to start. This was never occurred. So this violation
I'm tempted to ask questions, but perhaps, unless you object.
I have no objection, and I'd be happy to sort of address each violation on both sides if it's helpful, as opposed to all, one party's case and then the other party's case. I'm happy to address each violation as we go, if that's helpful.
Oh, you want to proceed violation by violation?
If that's acceptable to the other side, it'll kind of organize it a little better, I think.
Sure.
Okay, and would you object that Mr. Palacios ask and I each ask questions
No
if
objection.
we don't understand the testimony? Okay. Well, I've read the case, and one thing that came to mind is this, and it'll come up later. This business of the permit. A permit was issued to some entity regarding this what do you call it? Generating plant?
Central utility. Central utility plant.
Yeah, the central utility plant. Did you bring a copy of? Does EPA have a copy of this permit?
Right now, the Naval Hospital Guam is operating on an interim permit for their facility. They requested for an interim permit, I think, later on during this process.
Do you have the interim permit?
Yes, we do, I think so.
But not with you.
Not with me.
Okay.
I don't know whether WWO has a copy of the interim permit.
I don't think we have a copy.
Okay.
Right now, their permit is under current review. I think the time frame for that permit for the actual permit itself is I think is up, will be issued by this week, 4 or 5 years.
So what happened on February 15th? What did you do?
February 15.
Well, February 15th, was that the
The
date
date
of
of the spill.
the spill?
Okay.
This is technically, if I may, that's a separate violation, right? The first one that he's raised is in regards to
The
notice of
notification.
startup.
Yes.
And that is technically a separate violation from the spill.
Well, okay. Well, when did you first become involved in aware of the case? Or?
February 15th, sir. What happened was that on February 15th, we were notified by, one of my staff here was notified by somebody from the Navy Environmental that there was a spill up at Naval Hospital. And that's how we came about the knowledge that there was a release from the boiler, from the fuel from the boiler coming back to the gate tank.
Right. So did you go to the site?
We had if you look at the report, that the person that was initially responded to the site was Mr. Roland Gutierrez. And he did respond to the site, noting that there was a release and that the contractor, which is WWO, was supposed to obtain an environmental company to start cleaning up the and that's where it started. What we did was on Monday of the 17th, on the 17th, we went up there and did a follow-up inspection of the site to ascertain what caused the release at the site. Based on that, we found out that the unit was being operated without Guam EPA's knowledge.
Well, is GEPA alleging that the respondent was the owner of this?
The respondent is the contractor, or contractor that operating the unit itself to test run for the new hospital site.
Responsible party.
Responsible.
So what is your evidence that they were the operator?
Pardon me, sir?
How do you know that the respondent was the
If you
operator?
notice that there was no NRC report that came out with this from Mr. Moon, that stating that, hang on, it's like going back and forth on this. I think that it was dated 1/15/14. This was reported to the National Response Center and indicating that there was a release, a suspected release, and the responsible party at the time was WWO, according to this documentation.
Okay, does the interim permit contain a?
The interim permit was given or issued by the administrator after the spill had occurred, where the Navy was supposed to take over the facility. So there was no permit issued prior to the Navy accepting the site, the facility in itself. There was no administrator's official documentation telling the operator, which is WWO at the time, to operate the units at the site prior to the turnover of the facility to the Navy.
Okay. Anything else you want to add on this this number one?
We believe that WWO is the responsible party, and prior to starting up with the unit, they should have concurrence from the Navy and with Guam EPA to determine whether they have authorization to start up the units, and that didn't happen. Therefore, there was no written letter based on the regulation itself. It's required that a written letter be submitted to the administrator to obtain the permission to start, and a response will be given back in writing that you are authorized to start.
Okay. Thank you.
And if I may, Your Honor, I would just like to add, based on the March 20th letter from Mr. Alex Oviedo, he's with the Department of the Navy, with this agency.
So you wish to reintroduce an exhibit?
Yes, sir.
Okay. And could you mark it and?
Okay, as A1, I think is what we agreed to.
Is it something that needs copying, or can you just give it to me? I mean, we need to make a.
I may have a copy of it.
Okay.
Is that part of your submittal also, sir?
Number 5, I believe.
Yes, it's listed as
That's
number
ours?
5.
Yeah.
It's part of the information provided on the appeal.
Well, you know, I have my copies, but I was hoping to make a
Separate copy for
completely separate pile of documents. That's the record. And
Well, what we can do, sir, is have one of my staff get your copy.
It's the one that's scanned. It's toward the back.
Yeah, that's, I have that, but it's in a different order here.
Oh, okay.
Where is it?
What I can do, sir, is give you my copy. The facility.
that's going to be the record, the record copy.
Yes, sir.
Marking it as Exhibit A. So you wish to, Mr. Ferrara, to introduce this, or do you want to be a witness and introduce it?
I'm okay being witness, and I'll introduce it.
Okay, so we have, okay, would you please raise your right hand? You solemnly swear or affirm to tell the truth and whole truth, but nothing but in this matter?
I do.
Thank you. Mr. Palacios, what is your name and occupation, full name and occupation?
My name is Eric Palacios, and I'm the administrator of Guam EPA.
So you have an exhibit that you wish to introduce?
Yes.
As exhibit, marked as Exhibit A, and what is it?
It is a March 20th letter from Mr. Alex Oviedo with the Department of the Navy to Guam EPA, and specifically paragraph 2, and this is in furtherance of what Mr. Pereira's earlier testimony, and that is the actual date of turnover for the new hospital was March 19th, or a month and some days after the release had occurred up at Naval Hospital. And then he goes on to state, therefore, we can request for your immediate or conditional approval of the application to modify the air pollution control permit. And so just to reiterate what Mr. Pereira had stated, the spill violation occurred prior to the interim permit being issued, and the Navy also right here clearly states that the actual turnover date, which means when they assume responsibility of the site, was on March 19th. That, we believe, squarely puts the responsibility of the site on the contractor at any and all times prior to this date. And that's why we believe that that WWO is the responsible party in this matter.
Okay. Now, where is that exhibit? Have you seen this?
I have a copy, yes.
Have any objections?
I have no objections to the exhibit.
Exhibit A is introduced into the record. We mark this by stipulation, and it is a letter to the administrator from Department of Navy regarding the date of turnover.
Assumption of liability and interim permit request.
Okay. Do you have anything further? You're free to address the evidence on number one.
The only other point that I would like to expound on, and again in furtherance of Mr. Pereira's earlier statements, is that at no point throughout this entire process did Guam EPA, under my signature, issue an approval letter granting the operation of the boilers, and that's it.
Right. Since we're going violation, are any other witnesses on this particular point that you?
No, Your Honor, it would just be 4 of us.
Okay. All right, then, under our procedure, the EPA is rested, and it's your turn to cross-examine if you wish, and
I would like to cross-examine, Your Honor. Mr. Palacios, did I provide you with the stack of the exhibits that we intend to use?
Yes.
If you could refer to exhibit, I believe it's 6. And, Mr. Hearing Officer, exhibit 6 and the stack that we give you, I think it's yes. Yes. No. It's a June 14, 2013 letter to you from Captain Heckman of the Navy. Looks like that. Yes.
dated June 14th.
This
Is that not the stack that I gave you? That is what's a
is
little
just
different.
one.
Let me just give you another one.
What I have marked as exhibit 6 is
That's not
a
it.
separate.
Let me just give you this stack.
Okay. Thank you.
That exhibit 6.
It's a little over half on me.
It might help to pull that binder clip off, and then you'll see the staples will help you.
Okay.
I did the same thing. Towards the back.
Here we go. Okay.
Can you just take a look at that for a moment, that exhibit 6, just the cover letter in particular. Captain Hickman.
Okay.
All right, have you seen that before?
I don't. Right, well, it has, it's stamped received by our agency. I don't recall, whether
This
I
one in particular?
read.
Understood. The stamp that you're referring to is in the bottom left corner. That's a June 14, 2013 GEPA received stamp. Right?
Correct.
Okay, and so, and the letter was addressed to you up at the top of that corner, correct?
Correct.
Any reason to think you wouldn't have received this, given that it was received by the agency? Is this something that normally would go to you and being addressed to you?
Well, it depends. Usually, during the intake process, depending on certain keywords on the, the various cover letters, it goes directly to the programs at times. At times it will come to my office, and then I disseminate accordingly. But it really depends on what exactly is stated.
Okay. Did you perhaps also receive a copy of this by email from Mr. Maris?
I did, I believe, a week ago,
Okay.
around there.
All right. If you look in the first paragraph, this is basically a submittal by the Navy, and I'll just quote, Naval Facilities Engineering Command, Marianas, hereby submits the enclosed air pollution control permit application. So this is a air pollution control permit application, right? And if you look at the third paragraph on that cover page, on that first page, and it says on that third paragraph of the first page, enclosure 8 is contractor's schedule for installing, testing, and commissioning the generator. Request approval for emission units and other items. Did you see that?
Yes.
And if you would turn then to the very last page, the attachment, which says enclosure 8 at the very bottom, the very last page of that exhibit.
Yes.
Does this contain all the attachments?
That's all one exhibit.
Well, it's the last exhibit in.
Correct. And the very last
Mr.
page.
Mayor, the final attachment looks like this. Second from the last page. And there's not one for the one more.
You'll need to undo that binder clip also.
Just go to the second from the last page. Is the final attachment, and that's our.
Okay.
There we go.
Okay.
And I'd like you to just take a look at that contractor's proposed testing and commissioning schedule.
Okay.
And so this violation is in regards to the startup notice for boilers, correct? Referring back to the original notice of violation.
Understood. But if you look at the regulation, it says that 60 days.
One moment. So what we're talking about then here are lines 490 and 491 on that last page, where they indicate first 200 bhp steam boiler. You see those two lines, Mr. Blank?
Correct.
And so it does indicate a proposed startup date of July 15th, 2013, right?
Correct.
For both of those. So, in your opinion, does that not qualify as notice of a startup date?
It is an accurate notification
Okay.
in that it's very far off from when, and I understand, you know, things change during projects, but this was, our position is that this happened too far or too long ago.
All right.
And as Mr. Pereira was going to point out, we did not receive ample notification in the form of within 30 days of the startup date. This is many months ago.
All right. So the proposed startup date is July 15th, according to that, right?
Correct.
And the date received on the letter is June 14th, right?
Correct.
So that's actually within 31 days or a month and a day approximately.
Right.
So not several months, it's within a month, right, of the startup date. If the startup date was July 15th and this was received June 14th, approximately a month, maybe a month and a day.
Well, was that the actual startup date
Right.
of the boilers? I don't think so.
Okay, what was it to your knowledge, the actual startup date?
On or about February 15th.
Okay, you think that was the startup date, the date of that spill was the startup date for the boilers?
I believe so, sir.
All right, and just to be clear, we're kind of talking about two different things, right? The boilers are not what leaked and caused the spill, correct?
Understood.
Okay.
It's the equipment that's installed, that's wired to the boilers that caused the release.
Just trying to make clear for the hearing officer, we're technically, because these are separate violations, the spill versus the startup notice, these are two different sets of equipment. So, talking about the boiler still, and as to the startup date for the boilers, you're of the opinion that it was February 15th, the date of the spill?
I believe so, sir.
All right, and
But I could be wrong. We're trying to check out, I think what happened was that during the process of the operation of the boilers, I think WWO requested PCSP to do a smoke test for the units, and I believe that is the startup date. And we can confirm that based on an email and I believe that was in 2014 or something.
if we would take a look at the very last exhibit in that stack that I just handed you, Mr. Sablacios, Mr. Mayor.
The color
chart. So as to the actual startup date.
factory startup, and it's 5 lines down. Factory startup.
So that's the CMMS 1220, just begin with that line.
Sorry, what was this one? No, startup. Factory startup. Builders.
CMMS 0830.
Okay. 1230 or 1220?
Down in the next
Okay, there.
group for the hospital.
Okay.
And you see that factory startup boilers line? And then as we across that line, there's a 26 August 13 start date.
Hold on a minute. We're looking at the, I'm sorry, my apologies. We're looking at the wrong line. We have to go to the
0830, right?
CMMS 1240.
All right. So we are back up in that middle section there. That CMMS 1240.
That's the factory installation verification and system readiness, August 12th.
Yeah, you're right.
That's when we did the start on August 12th.
So where it says factory startup steam boiler feed water unit, is that the one?
Factory installation verification and system readiness, boiler water softener, factory startup, yes, both of those ones.
All right, so those, and then just to check, Mr. Hearing Officer, do you see, I jumped around a bit. Do you see where I'm at on these?
I see 1240.
Yes.
What's the other line?
1220,
1240.
right above
I
it.
see them both.
All right.
Sir,
And so,
if I can just interject for a
well,
while.
let me just ask you, so if that indicates a 12 August 2013 startup date, do you have any reason to believe that's not correct?
If you haven't received a confirmation letter from the administrator telling you that you can start it up, then you haven't received an approval from the agency to start up the unit.
Understood.
In addition to that, on April 11, 2014, an email from Mr. Mike Park to Mr. Erwin Cruz regarding the intent to perform initial startup.
Before we jump to another exhibit, if I may just finish
I
with this one.
mean, we're jumping around regarding what is the startup date and this. The Navy is stating that, hey, we're going to start up this unit on April 11, 2014. So where's the actual startup? I mean,
So do you have any reason to think that this August 12th date is not correct?
I cannot ascertain
don't-
that. I don't know.
Oh.
I wasn't there.
Okay.
Based on the email from the Navy and from Mr. Park,
Yes.
the startup date is April 11, 2014.
Understood.
Understood?
Okay.
Too.
So if that August 12th date were correct, because you have no...
Which I don't know.
If it were correct, then the notice that was given to GIPA was in fact within 60
Understood.
days.
But the contractor never received a written letter from the administrator telling him that he can start up. That is in the regulation.
I'm going to ask that you answer the questions first, and then of course you can feel free to respond.
I don't have any knowledge of when they started up the unit.
Okay, you have no knowledge. So
No,
if-
sir.
If that August 12th date was correct, and this notice of June 14th was received as indicated, that's notice within 60 days of the start, correct?
Understood.
Okay.
I think at this point, though, it's speculative because he's saying he has no personal knowledge of it.
And then to the extent we're going to do a little argument, of course, it's the burden of the agency by a preponderance of the evidence to establish the violation, and so simply saying we don't know is insufficient. So that's certainly argument.
But did you guys receive a, sure,
And if I can have Mr. Mayers explain by way of witness testimony, and let's have you sworn.
Is there any exhibits you want to introduce at this time or later?
The same exhibit. Let's wait until he swears you so that you can testify.
Okay, please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth in this matter?
yes, I did.
Thank you. And please state your name and occupation.
Richard Maris, and I am the project manager for the project at hand here. I represent the joint venture company.
Mr. Bisacki.
Mr. Mayers, if you take a look at Exhibit 7, which we've been talking about the last several minutes, could you explain to us what this Exhibit 7 is?
Yeah, yes, sir. We track all of our activities through a scheduling program. For common in the industry. And we track the anticipated dates and then the actual dates. This report that you're seeing is from our contractual schedule, and these are the actual dates for these activities. They're actual once they happen. And as we move through time, we correct the date to the actual date, and it constantly progresses. So we're able to go back and look at any activity that we've done on the project and tell you when it did happen. In fact, when it did happen. These schedules are submitted to the Navy on a monthly basis. They're scrutinized and analyzed by a scheduling specialist on their part for any inaccuracies. And anything represented here can be taken as accurate.
And just to be clear, a follow-up question. So we were looking at Exhibit 6 previously, which was the letter from Captain Heckman dated June 14th. And this exhibit, which had a different start-up date of July 15th. The Exhibit 7 was submitted later, correct? After this June 14th submittal.
Yes.
So the June 14th proposed start-up date of July 15th basically changed, is that correct?
That's correct.
And in fact, the start-up date was what was indicated in Exhibit 7, August 4th, is that correct?
Correct.
Mr. Harry, Officer, I just want to,
One moment, since we have anything further, Mr. Myers?
On this
On this
violation?
point?
No, sir.
Okay. All right, is there any other witnesses for the respondent on this point?
You want to ask David?
Mr. Miller can testify sort of about this, in terms of this one. I think Alex was the one that's going to talk about the submittal of this, but to the extent there's not a dispute that it was received by the agency, I don't know that we need to submit any more testimony on the submission of the document, unless there's something. We'll get to that.
Okay, right, then, that's your rebuttal. I guess you could have, no, that's your defense. You have any rebuttal?
yes, sir. In our regulation, section 1102.1, prohibition of air pollution, it states, no person, including any public body, shall engage in any activity which causes air pollution or cause or allows the emission of any regulated or hazardous air pollutant without first securing an approval in writing from the administrator when required by this standards or regulation, which WWO did not receive an approval in writing from the administrator.
Right. Was that question, whether they received the approval ever, was that?
Yes.
I think this is a separate issue. He's talking now about approval as opposed to giving notice by WWO.
Well, it's the same thing, approving for you to operate the units during this time on that other section. It's just going further back on the regulation than what you have to do. It has to be in writing. The administrator has to write a letter to whoever the operator that he's authorized to operate the unit.
WWO wasn't cited. You didn't cite WWO for failing to get approval, right? That's not in the violation anyway, is it? The violation indicates, number one, WWO violated provisions of this section by failing to notify the administrator in writing of the startup of the 3 boilers at the facility that caused the release of approximately 2,000 gallons of piece of fuel into the environment. Doesn't say anything about failing to obtain the approval.
But still, the days prior to the startup.
So just to be clear, that wasn't in the violation at all, right? The failure to obtain approval. Okay.
And actually, as far as the notification, it's actually 61 days if you count the day we received it. So it's outside of the 60-day requirement.
Between June 14th and August. I'd have to get a calendar. I'm guessing it's not 61 days, but I would have to. We can take judicial notice of exactly how many days.
What are the 2 dates?
June 14th.
and August 13th.
I think it's August 12th.
13th.
August 12th. We started
It was
on
August 12th.
August 12th. I'll check it later.
Yes.
So our plan was to address, both sides to address the accusation number 1, and it appears that we have.
I'm sorry, we do have one more point to make, and this is in regards not to the notice per se, but as to the language of the violation. And Mr. Pereira, in the violation, you write that that WWO failed to give notice of the startup of 3 boilers.
Understood, I stand corrected, it's 2 points.
Okay, so there's only
Well, in addition to that, they never gave notice for the 2 additional generators.
well, so
Understood.
it's not 3 boilers, it's 2
It's 2.
boilers, right? And the generators is not involved at this point, it's not in the site.
It's an emission source, that they have to notify the agency.
But I think it's agreed then that there are only 2 boilers.
Yes, sir.
I think we have addressed violation number 1 unless the agency has anything further.
We'll move to number 2, which states that it's unlawful for any person to, well, the regulation of the statute states it's unlawful for any person to violate any provisions of this chapter or any rule, regulation, standard, or order issued pursuant to this chapter. The accusation is to respond that violated provisions of the Solid Waste Management and Liquor Control Act as delineated below. Well, that incorporates accusations 3 and 4, does it not?
Yes, sir. And those are the issues where the fuel from coming out of the boiler, going into the tank, if a defective solenoid causes the release. And we consider the fuel to be a solid waste.
Okay. Well, who wishes to address the evidence?
Well, the evidence stands in itself there. If you look at all the pictures and the side that the release of the fuel, the cause.
Do you want to introduce any pictures or
I
exhibits?
think that's part of the
See, I mean, I got some pictures, but we're making a record here.
okay. I'd like to provide you a copy of the NOV, and on the NOV itself, there's some pictures on the site.
I mean, let's see, is this going to be the record copy?
Yes, sir.
There's an inspection report as well as
Also, the NRC report is in there, certifying that there was a release of the site.
okay, well, we don't need the notice of violation. No, these one, you know, beginning here, you wish this is the record?
Yes, sir. And we also like to include the stuff on the NRC report. And also, we like to also include the unit as part of the release of the site. It has pictures in there. Oops, sorry, sir.
officer, I am gonna request copies of that. We may have that same thing, but I think it would be helpful for us to make sure we're referring to the same thing. If they're able to make copies.
All right, who is here to make copies for us? There's two different exhibits, it looks like to me.
How many,
Sir? Excuse me?
how many copies?
I'd request two.
Two.
Side, I'm not sure.
And one for you.
Just on the housekeeping matters, the exhibit 6 and 7, that we were just referring to, Mr. Mayor's testimony. We would of course request that those be formally admitted.
Mr. Palacios, do you have any, we should examine these again, do you have any objection to that?
That's the June 14th Captain Hecton letter we were discussing in
Right.
the
Right.
startup.
Okay, admitted by stipulation, no objection. And could you just give me a description of
June 14th, Captain Hecton startup notice.
Captain Beckman started? Is exhibit 6.
Correct.
And exhibit 7 is?
That would be the as-built actual startup date.
Sir, Mr. Hearing Officer,
Yeah.
for the record, it's the subject is reference, this is from WWO, and on that particular document, under the notable email, it states that on April 11, 2014, from my part to Aaron Cruz regarding the intent to perform initial startup and pass the meeting. I'd just like to turn that in as part of the exhibit also.
Okay, this was an attachment to the notice of intent to appeal, was it not?
Yes, sir.
It was, earlier I said that the notice of appeal was the initial documents in the record. So it's already, unless you have any.
I'm not sure if I could actually just take a glance at it because. But this is not the actual email,
Right,
right?
actually, what we'd like to submit is the actual email.
Probably in the
We need the actual email.
Just to let you know, Mr. Hearing Officer, the dates on the document are incorrect.
Which document?
The documents that I just presented to you, the first page,
This?
the email address are dated 2014 versus 2013.
Well, this is,
If you look.
this is
on
not
the-
email.
No, I'm just on the notable emails, if you look at the dates,
Notable, this,
the information that you're after, the dates are incorrect. Based on the email that was submitted by WWOs, I think some of those dates are 2013. So the document in itself is questionable.
so you have evidence on that point?
Yes, sir, we got email, a copy of the emails that was submitted as part of the package.
I don't think so.
But you have, but since this was an attachment to the notice of defense, you have no objection to it?
I have no objection.
Yeah. But you wish to introduce this? Well, it's already in the record.
Yes, sir, but just to reiterate that the dates on those notable emails are incorrect. The 6/2014 or whatever dates they have, those email dates are incorrect.
Just to be clear, that email is not before the hearing officer, is that correct?
No, I don't
see it.
Right, the actual email from Alex.
What we like to do is make you copies of the emails also as part of
Yes, that's what.
the documents.
Oh, you need to do that now?
Yes, sir.
Oh, okay.
is a April 11th email from Mike Park to Erwin Cruz, is that what you're referring to?
I think it's dated 6/24. On the document itself.
Which document?
Page 1 of
Page
3,
1 of 3 on your appeal letter.
if you notice the dates, you're a year ahead in a sense.
Okay, no problem. So you're talking about the notable emails references?
Yes, sir.
All right. So the April 11th email in particular, or just talking about all those dates?
All the
Okay. Understood. So I guess the point is that those should be references probably to,
correctly.
I don't know if they're 2013, but I think that's the point you're trying to make, right? I'm not sure if that makes sense, Mr. Hearing Officer. We're talking about the reference dates for those notable emails, and they all reference 2014, and perhaps those should be 2013.
Just if you notice the last paragraph, it says 7/5/2014, we're still in June.
Right. Does that kind of bear on any of these things in terms of
I believe the documents, whatever you put in there is incorrect.
Fair enough, if it should be 2013,
Whatever that, dates are.
but that doesn't actually impact the notice document that we looked at before, right? These are totally separate typos,
It's
essentially.
possible.
Okay.
Copy to you, sir.
Thank you.
And a copy to you. I don't know what that civic number was.
Okay, so you were testifying,
Do you want your two
you
copies?
were introducing
As part of the,
a collection,
Thank you.
of photographs.
you requested copies of the photographs from the site.
Yeah,
As far as evidence
10 photographs taken February 15th, 17th, and
Yes, sir. The 15 was the initial response by the person that's on duty for the emergency response for the agency. There's also pictures from Unitech Environmental on the spill itself.
this would be Exhibit B. And what do they photographs purport to show? What's
It
your
shows
purpose?
the extent of the spill and what happened to it, how far it impacted the environment at the site. In addition to now, the site is still has some contamination, and we're looking at the proposed remediation of the site. It appears that the cost for the spill is over $300,000. For the cleanup of the spill is over $300,000, I think.
Okay, in offering Exhibit B, you now have a copy. Do you have any objections?
No objections.
It was introduced by stipulation, and so photos of the site on February 15th and 17th of this year. So you were the okay. So I think we're 2 incorporates 3 and 4, so we're on to 3, which accuses the respondent of placing solid waste upon property adjacent to 3 storage tanks located at the Central Utility Plant, Naval Hospital, Guam. And you've introduced photographs. Any other evidence?
No, sir, not right now.
And,
Depicts what transpired when the spill occurred.
any other witnesses on that point? You're saying that the respondent allowed this, and,
Yes, sir.
so the spill occurred, but you're saying the respondent allowed it, so any evidence on?
Yes, if they had actually taken the initiative to have somebody on site when they're testing the unit, I believe that the the extent of the spill will be a lot less. What happened based on the NRC report is that I believe that they left the site around 5 p.m. after working hours, and from there on, the spill occurred until the next day at 6 a.m. or 7 a.m. when somebody saw the release at the site and reported it to the federal government environment.
You're relying on an NRC report?
No, sir, I'm just telling you that the NRC report also depicts that there was a release at the site that's more than 2,000 gallons.
Should that be an exhibit?
I believe that should be a part of the exhibit, and it is an official documentation that was sent to the National Response Center in the state that there was a release at the site.
Well, do you have a copy?
Yes, sir, we can provide that to you too. I think we did provide it, sir.
Yeah, we're just building.
You want a separate
Yeah,
copy?
separate. I want my own copies, but I want to see.
I think, sir, it's part of the exhibit in this one.
For the unit tech, I think I found the unit tech report, but I.
There was.
February 15th.
It's on the page 5.
Some description
Right here.
Part of the photos? No, but just figure that. We got a copy of it, but they may need a copy.
Sir, this is the NRC report.
This is the NRC report?
Yes, sir. That goes to the states. Whenever there's a release at a federal facility, the Navy is required to submit a report to the National Response Center.
Working is exhibit C. They were offering into evidence what's been announced as exhibit C.
Thank you, I have that. I'll get you.
They admitted by stipulation and the NRC report.
There's a number in there also, sir. If you notice, it's number is 1074062.
Okay, 107 4062.
Yes, sir.
So on the issue of whether the respondent allowed it to be placed, is there other evidence, other witnesses?
Probably, sir, if you look at the cause of the stuff, that's more evidence than.
So you rest on the evidence and the accusation?
Yes, sir, I think so, sir.
Yes, Your Honor.
Okay, Mr. Guzowski?
Yes, Your Honor, I'd like to call Mr. Maris to testify and a couple other witnesses. This is where we'll put on the bulk of our witness testimony.
Okay, Ron, you're still under oath. Mr. Mayor?
I'm sorry, was he sworn earlier?
Yes.
Okay.
Yeah, Ron, you're still under oath, and your testimony on the accusation number 3.
Your Honor, my testimony is going to be to establish our contractual relationship with the Navy and our relationship with the tanks and the fuel store. So, back in 2011, the Navy awarded WWO a contract to build a new naval medical center, which included the central utility plant, 2 new tanks, and 2 boilers. But the contractual relationship is what we call a hard bid, meaning the government, the Navy in this case, provides all the contract documents. They provide the plans and the specifications, which are down to each and every piece of equipment and material that gets used on the project is depicted or described or shown on either the contract documents or within the specifications. There was no piece of equipment down to screws used in this hospital that isn't described in the contractual specifications or in our contract some way, somehow. What I'm trying to say is that the design of the hospital and everything in it, every piece of equipment in it, down to the screws, is provided by, the description of, is provided by the government. The government hires an architect of record, engineer of record, and the architects and engineers provide the plans and specs. So I hope I've been clear that there is no element of design build here. There is no element of the contractor providing any of the information that ultimately becomes the materials used in that building or how they're assembled. Everything, the complete design, everything comes from either the government or the manufacturer's instructions of the materials that the government specifies, including the tanks, how they were assembled, the configuration of the piping, and all the pieces used. So we are, to understate our position, we are merely the installers. We're the eyes and the hands of the architect and the government with their design and what they want. We put it together. They tell us what to do. I think that's about all I can say on that.
And if I may, with just a couple follow-up questions. So, did Watts, Webcor, Obayashi contract with subcontractors to assist in the actual installation?
Yes, within our contract and the building of the hospital, we have over 150 subcontractors, providers, and installers. The primary, the main subcontractor is the mechanical plumbing contractor, and then the Dorvan Lease, represented here today by Mr. David Lease. They provide all the mechanical functions, elements of the hospital, including the central utility plant elements.
But WWO is the prime contractor, was responsible for the oversight of all this stuff.
Absolutely, we are responsible for the oversight of everything that happens in the hospital.
And to explain in a little more detail than exactly the work done in regards to these above-ground storage tanks. These are fuel tanks, right?
Yes, sir.
And if Mr. Hearing Officer would take a look at Exhibit 1 in our packet. And I believe you have that Exhibit 1 as well. That's just a basic photograph of the tanks that we're talking about, right there on top. So there are 3 tanks, marked 1, 2, 3.
If I may?
Yes.
Okay, now the hospital had an existing central utility plant that we added on to. We added the 2 outside tanks that you see in the photograph. The center tank was an existing tank that fed an existing generator. So this facility was already here, permitted under Guam EPA, and the permit in question here is modification of that existing permit.
So the tank numbered number 1 in that photograph, that was the existing tank.
Yes, sir.
2 and 3 are the new tanks that WWO installed, right?
That's correct.
That's actually not correct.
Okay.
The middle tank is tank 2. That's the existing tank.
I'm sorry? This
We have a
exhibit
number
is wrong?
restriction.
This numbering is
Yeah.
not correct?
Number 1 is, it goes
I think tank
right
1 and
to
3
left.
are the new
Yeah,
tanks.
1, 2 is the center tank, that's the existing tank. 3 is.
Can I make corrections on the exhibit? It might be easier, in fact, I'll allow Mr. Yates to do it to make sure. All right, and let's just make sure yours is, we've changed our number in 3, correct, this becomes 2. If our tank is 1. Mark this middle one, number 2 is the existing tank. Okay. And since this is what we're gonna Thank you.
Okay, good. Can you start over and?
Yes, we'll go back to the tanks, now that we've renumbered them. On exhibit 1, we've got tanks numbered 1, 2, and 3. In fact,
So
they're,
the outside tanks are the new tanks.
Yes.
The center tank was the existing tank. These tanks feed fuel into the central plant, into the 3 generators and the 2 boilers that now service the hospital. The feeding of the tanks is not a simple arrangement of mechanisms. It's a very sophisticated series of pipes and valves and solenoids and electrical appliances that service this. I'm going to have Dave will give us more detail about how they work. But this is not a, you're not looking at something that's simplex. It's very complicated. With each piece of equipment, Dave, you can correct me from, I'll let Dave go into the detail. It's a very sophisticated piece of arrangement where the boilers and the generators actually identify themselves as needing fuel, select fuel from the tanks, and it's not like a gas tank in a car. It's very complicated, and the engineering of it is sophisticated. I just do want to point out that the engineering of this, of all of it together, again, does come from ASMA, comes from the government. They tell us what to use, how to use it, where to put it, when to put it in place. And almost at every step of the way, they're watching.
And your subcontractor?
It's DDL, or what's called DDL, and that's Mr. Dave Yates here represents them. Dave has superior knowledge of the system over everybody, because he was the person responsible for installing and examining the case.
So you're saying that DDL was using all the material specified by the Navy?
Absolutely.
In accordance with the Navy's plans?
Absolutely. Absolutely. It wouldn't be on, they would not, we've already turned over the system. There's been evidence. Those parts wouldn't be there if they weren't the right parts. We've gone through a very sophisticated process of commissioning, inspection, thousands of inspections. The pieces that you're looking at here in the picture have been inspected hundreds of times. It's a contemporaneous inspection process that happens out there. So every day they are out there with us watching what happens.
Thank you. Anything further?
No, sir.
Do you have any questions of Mr.
Yes, I
Moore?
do, sir. So, WWO hired a subcontractor. Is the subcontractor, is the Navy responsible for the subcontractor also?
The Navy's responsible for the design.
Understood
Direct
the
answer to
design,
your-
the drawings
to your
and
question.
everything.
The government is not responsible for our subcontractors. Watts Webcor Obayashi
So-
is solely
okay.
responsible for the
Understood.
implementation of the contract.
Understood. So if your contractor installed a defective solenoid valve, why didn't the contractor replace that defective solenoid valve during the process of, testing it out, making sure that this solenoid valve is okay prior to operating the unit?
The solenoid valve is not defective, sir.
According to the documentation, the solenoid, one of the solenoid valve that's operating return fuel to the tanks is defective.
No, sir. The solenoid valve actually operates exactly as it's intended to operate.
Okay.
Dave, when he makes his testimony, will explain in detail that the solenoid valve is
Well,
the
let
wrong-
me go back.
Can I finish, sir?
Okay.
Can I finish, sir?
Okay.
The solenoid valve is the wrong choice of equipment for where it's being used.
Okay.
And Dave will explain in much more detail than I'm a layman compared to Dave.
Okay.
But in direct answer to your question, that solenoid valve is the valve that was specified, and it does what it's supposed to do.
Okay.
But in the environment that it's placed,
Understood.
it causes a problem.
Right. Let me just rephrase the wordings I have. I believe that the wiring to the solenoid valve was incorrect. Is that correct?
The wiring to the solenoid valve after the night of the 13th was correct.
After
The night of the 13th, before the spill, the wiring, I think what you're alluding to is there were some wiring issues with the solenoid.
I don't know whether it's a solenoid valve.
Sir,
Okay,
please,
go ahead, finish.
let me finish
Okay.
this. Okay, there were some issues with wiring that were connected on the night of the 13th, before the spill. When we left on the night of the 13th, all elements of the system were wired up as they should be.
Okay. So the cause of the release was,
I'll let Dave, well, if you want my layman's opinion, again, I'm not a mechanical engineer or the expert, the cause of the spill is a design error on the part of the government, who hired Sherlock Smith and Adams to engineer and develop the system. It doesn't function correctly. We all know that it doesn't function correctly because that's evidenced by the spill. What caused it is, again, it's a very sophisticated system. The solenoid valve that's in place doesn't work with its other pieces of the system the way it should. Dave will tell you that what should happen there is the solenoid valve should come off, and there should be an electronic positive gate valve, a mechanical gate, electrical operated gate valve, mechanical gate valve put in its place, not a solenoid. That way the gate valve opens or closes positively instead of as a solenoid, which has it has a gravity drop on it, and you hope that that it closes when it's supposed to close, as opposed to a positive electronic valve would close on demand or open on demand. And it is our position that the government has misdesigned the system, and they're still struggling with the entire system and how to fix it.
so what you're trying to say right now is that the operation of the facility for the boilers is still being operated manually. Is that correct?
That's correct.
And is it the responsibility of WWO to rectify the problem based on your contract?
Only in terms of the physical side of it. The engineering side of it has to come from the government. We are still waiting for the government to give us a new design and a change order to go implement the change as they see fit. When it is our responsibility to do the work, but we are never, ever are we the designers, the engineers. Never. We are always just the installers, and it's a simple statement I just made, but it's a philosophy that we have to preach on the job on a continuous basis, because as builders, we're always looking for solutions. And we always have to remind ourselves and the owner that we're not the engineers. We're not the architects. We are simply the hands and eyes of the design intent.
You mentioned physical, during your process of explaining this.
I'm sorry.
What do you mean by physical?
We do the work. We don't do the design.
Okay.
We only do the work. We are not designers. No, sir. And under no circumstance are we designers or taking any responsibility for the design.
So is there any way that during the process of the installation of this device that you contacted the contractor, the Navy contractor, ROCC, the person, the federal government that's assigned to your facility, which I assume is a professional engineer, telling him, hey, there's a problem with this. Have you did you notify that person?
Well, there is no notification possible, and this is probably the part, I got Dave behind me. Yes, they are aware of the installation process continuously. What we're describing here, the incident, it took everyone by surprise. The contractors, the Navy, the architect, the engineers of record. And it continues to befuddle the engineers as to how to come up with a solution. It's not something that was anticipated. Of course, we would not have allowed it to happen. You mentioned that the cost so far was $300,000. Sir, the cost to date so far is $900,000.
Oh.
Out of our pockets, our collective pockets, $900,000 so far.
So,
The issuance of the penalty on top of you're adding acid to an open sore. It's nothing that we've done wrong. We actually responded very responsibly. The moment we got on site, we called our environmental action people, and we spent $900,000 without anybody asking us to remediation of this issue.
Okay, I've got a couple of questions at least.
Yes, sir.
Okay, I'm not going to get into the details of what failed, whether it was a design flaw or installation error. I don't think that's really why, right, it's not the issue. The fact of the matter is that, as could occur, and the people of Guam, we will not let the people of Guam be left holding the bag in any way, shape, or form, whether it's in the form of an impact down the road, 10 years from now. So a violation occurred. Is it then WWO's position that Guam EPA should have gone after the Navy for this NOV, or your subcontractor?
No, sir, that's not my position.
Okay, then it sounds like we're not supposed to have issued an NOV against anyone because of some design flaw, as you're stating.
Eric, you're asking me about policies that have nothing to do with what I do for a living. I can't suggest what should have happened, what could happen. It's a difficult thing that happened. We've spent $900,000 so far to protect the people of Guam. It is our position that we didn't cause it. How the GEPA responds, I can't offer any advice. I simply don't know.
Okay, I understand. Well, then my point is this: is a violation occurred. It is our duty to issue a notice of violation as a result of that violation having occurred. We believe that we issued it to the appropriate responsible party, which in this case is WWO. And what strengthens my position on that is, again, if we can go back to the June 14th letter from the Navy to me, that clearly states WWO will assume responsibility for the construction, modification, or operation of the source, and by extension, all the related equipment, including DSTs that feed the fuel to the source, in accordance with Guam Air Pollution Control Standards and Regulations, and any permit issued thereof during the period of performance until it has been turned over, which didn't happen until
March 19th.
Right.
Okay, I can answer that. Or I can respond to that.
Okay.
And nowhere in there does it say that we will be responsible for the design. It says, it describes all the things that we are to do, and I agree that we are to do those things. But this is a design error that continues to exist. And in nowhere in that document does it say that we are responsible for the design.
Okay. And I don't mean any disrespect, but can you produce a document that says it was a design error by someone outside of your company or a subcontractor?
I guess
Basically a third party that has no interest.
I guess I could produce our contract with the Navy, but, and a copy of the specifications, but everything in the contract and the specifications or the RFP, request for proposal, would clearly state that it's a hard bid job. The design is provided by the government.
Okay, right, but I'm not.
Can I provide documentation on that? Sure.
No, what I would like to see is some document that says it was a design flaw authored by someone outside of your company or anyone affiliated with your company.
If you would go to the Bison Engineering Report that's included in our package to you.
If I may interject, I appreciate the opportunity to cross-examine. We do have an exhibit that will answer that, and I guess we would get to that in due course. If there's any other questions as to this witness and the exhibits that are already before the hearing officer, we do have one. We will get to it, probably the next witness,
Okay.
and answer questions if that's okay.
I've probably spoken more than I need to. Again, I'm not the expert. Dave Yates is has superior knowledge over all these things in great detail.
But if you have any other questions for Mr. Maris, otherwise, I would have Mr. Yates speak to the details of this bill.
No further questions. Well, excuse me. No questions. No further questions. Thank you.
Okay. Swamp chairs.
I'm going to rest my mouth for a minute.
Any time for a break, if anyone needs a break, Mr. Hearing Officer, let us know.
You know, it's been going at an hour and a half. We'll take a 10-minute break.
Thank you.
We're back on the record now. See Mr. Gosowski.
Thank you. At this point, I'd like to call Dave Yates to testify.
Okay, you'll please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth in this matter?
Yes, sir.
Thank you. Please state your name and occupation.
David Yates, I'm General Superintendent with Dorgan Lease, the installing contractor in question. Dorgan D. Lease.
Okay. Is there some document that will have the name of this company on it?
There is. If you would take a look at Exhibit 3, which we are going to get to shortly in that stack.
Okay. All right. Please proceed.
Mr. Yates, can you explain your position at Dorgan Lease? Is it lease? Lease?
Lease.
What is your job?
My job on this project was General Superintendent. My job now currently is field operations manager.
Okay, General Superintendent, so you oversaw the installation of the fuel tanks at issue, right?
That's correct.
Can you explain for me generally what the installation process included, from some of the inspection and testing procedures all the way through to the actual installation of spill?
Well, and in summary, we backtrack all the way back to March of 2013 when we received the 20,000-gallon fuel tanks. There was an existing 20,000-gallon fuel tank, fully functional, that when we had dedicated point connections for us to tie into two new 20,000-gallon tanks.
All right, and I'm going to jump in from time to time just to slow you down. So on that Exhibit 1, the existing fuel tank we said was the middle, tank 3, right?
Tank 2 is
Sorry,
the existing,
tank 2, correct.
and that is the existing tank.
And so your job involved the installation of tanks 1 and 3.
That's correct.
Continue, please.
So, for everybody's reference, this central utility plant was a fully functional operational facility that we were to add fuel tanks to and boilers to. So we tied into an existing functional system, fuel system. Okay. Tanks were brought in March. We started our work. We went through a series of install, submittal process. Went through the design process. Had our drawings fully approved by the Navy.
I'm sorry, when you went through the design process, what do you mean?
What we have to do is extract the design information provided by the Navy and put that on coordinated shop drawings that we installed by them. So those drawings are basically, we were provided the design. All we do is produce drawings to install by them. So we did that. These drawings, all of our apparatuses, as Richard alluded to earlier, the design, the apparatuses, everything was specified clearly by the Navy through NAPAC. We were contracted strictly with WWO. There's a strict QC process in place to where all the products were verified, whether they met the Buy American Act, whether it met the specifications. If they didn't, there's processes in place through NAPAC to catch these things through a series of inspections or ongoing inspections. So we went through, we installed the tanks, we installed the piping, we did an initial startup of the fuel system. That system was actually started up prior to the startup of the boilers. We go through the flushing. Everything is witnessed by WWO QC department, and everything is witnessed by NAPAC field inspectors.
When you're talking about that startup process that you just mentioned, do you remember the approximate dates that occurred?
As far as the fuel, what I recall, it was May or June.
Of 2013.
Yes, that we actually started flowing fuel.
And the incident at issue is February of 2014, right?
That's correct.
So in fact, these tanks had been operated as much as 9 months previously?
Well, we went through and we were basically operating off the existing tank for some time. And I don't recall those days. So we had everything isolated off the other tanks. We went through a series, after we did the boiler startup, fuel was installed prior to the boiler startup, so we had fuel in the tanks. We went through a series of inspections and commissioning in late October, where we discovered, actually it was in August, where we discovered some design flaws. So what we found out during the discovery process of our system verification is that when the way the system's set up is, if the tank is energized, that tank has 2 pumps in it. That tank will pump fuel into the building to each piece of equipment, and the excess fuel that's not being consumed returns back to that same tank. So what we've seen as a design flaw in August was hey, we're seeing fuel return back to other tanks, not the tank that's being pumped. So at that point, we proposed that to WWO, forwarded that to NAPAC. NAPAC came back and finally issued a change all the way, I think it all went all the way into October, where they issued a direction to add these solenoids. It was fully executed in January. So we had to manually run the tanks, lock out, tag out the tanks that weren't being used until this change was fully executed. So we went through the process of adding, and the fix was, per the Navy, the fix is to add these solenoids on the return system.
Can I stop you for a second?
Yes, sir.
When we're talking about solenoids, take a look at Exhibit 2. Was that the solenoid you're talking about?
Yes, it's provided by Morrison Company. It was submitted, approved by the Navy, and installed.
So Exhibit 2 is a photograph, and what would you call this technical document?
I mean, that's a submittal. That's what we submitted. That's our vendor provided that data sheet, and we submitted that for approval. After full approval by the Navy, we purchased those solenoids.
Okay, so Exhibit 2 is a solenoid valve data sheet?
Yes, correct. Submittal sheet.
Submittal sheet.
This is on the record?
Correct. And I believe you have a copy as well in your stand. They have a copy as well.
Okay,
Any objections? Admitted, and continue.
So, if I can, so after the change was fully executed, we installed the new solenoids on the return system. The electrical contractor wired them up. We went through a series of testing that started in late January and February 10th. We went through a series of testing, what we call system verification, and when we do that with each system prior to commissioning through the Navy Commission. We have to go through and do our fully testing. Basically, we're commissioning the system first, and then we go through that with an independent engineer, through WWO and NAFAC to verify that we've met the engineer's intent. That's strictly what commissioning is verification of the engineer's intent. So we go through that system verification. We did some checking with our fuel manufacturer, Fields and Harper. He was our vendor. Went through that. We really didn't see any transferring of fuel like we did prior to adding the solenoids. During that week, we didn't see a whole lot of, so we felt like the system was safe. There was a glitch on the 13th, as Richard mentioned, on tank 1. Had nothing to do with tank 3, the tank that failed. We made some wiring adjustments on tank 1. We caught that through our system verification, our checkout process. So we put the system back on Friday. We run it every day. We have to, and when I say we run it every day, the hospital was scheduled originally to be completed on February 27th. Commissioning for the new hospital started November 22nd. We were turning over areas. So to turn those areas over, we got to produce steam. To produce steam, we have to flow fuel. So we were using the systems as they were designed to turn these areas of the hospital over. And this, basically, the CUP, the central plant, is basically just a support mechanism for the hospital that provides the major systems. So, we had to, these systems were running, we were burning fuel every day, making steam every day, which of course made domestic hot water, made heating hot water, so we could hand over the hospital so that the owner could start the touring process. So that, to say that we did no testing or no checking, these were functional systems for some time while we're turning them over. So we go into the week of February 10th. We go through our IV. We do find some certain things. We take care of the issues that we addressed. And let me back up one more time. One of the things that I do personally, it's not a contractual obligation. I have a guy that owns these systems. So, his job every day, and it came from August when we did our startup of the boilers. His job every day was to come in and check the boiler system, check the fuel system, make sure that chemical treatment is correct, make sure the fuel is flowing correctly, make sure the boilers are operating correctly, as well as other things inside the building. So that's something we do every day just to protect ourselves as an installing contractor, because we are in an operating facility. So on Saturday the 15th, after Friday, week the 14th, on Valentine's Day, we put the system on. I personally came back, we made sure everything was functional at 3 o'clock. We didn't see anything that would indicate otherwise. What we do is we take snapshots of the tank levels, and you can see fuel if it's transferring from tank to tank by looking at these tank levels. We take pictures of those, and I've got some on my phone right now. And we come back and verify that hey, those gallons haven't changed, because we seen there was issues before. And this was the fix. The fix was what we had initiated, or what the government had told us to do. So we came in, we got the system up at 3 o'clock. I had a meeting, I think an owner's meeting that day with WWO and NAFAC.
I apologize.
Yes, sir.
To cut you off. Just for clarification, when you say the government, do you mean the federal government?
The Navy.
Okay.
You know, NAFAC is, you know, who I call the Navy. I mean, that's who was our it's AHJ, Inspector Having Jurisdiction.
Okay, thank you.
So we have those owner meetings. I would go back to the plant, just as I do every day, walk down the systems and verify that I don't see anything that's out of whack. You know, I look at the boilers, I look at the fuel, I go to the air handlers, and that's something that we do as an installing contractor, you know, because things do happen, you know. So at 5 o'clock, we did a final initial walkthrough. Didn't see anything that was disturbing. Came back in the next morning around 6:20. My boiler guy that was checking the boiler ran the fuel come running over in a mad dash to me. We were having our safety huddle at the loading dock of the hospital. And he said, "Dave, we got a problem. I've shut the fuel system down. There's fuel coming out of the tanks." About the same time, DZSP showed up. This isn't a plant that's being monitored full time, you know, by the Navy's request. We actually had objections to that. We feel like the plant needs to be fully monitored, but that's not our contract. So they've seen it about the same time. There was alarms going off. Things were being enunciated. The overflow alarms were off. So all the safeties were working. There was just nobody there that could have picked it up at that time. So we go out. I walk up to see the fuel. Immediately, you know, my response is, we can't handle this ourselves. We got to get help. Went straight up to the general contractor, WWO, to their civil superintendent. We call him Lucky. John Luxinger is his name. Said, "Hey, I know you got contact with some kind of recovery people. We need to call them now." We placed that call. They were there within the hour. We had every excavator on site, doing everything we could that day. We worked 16 hours that night, 16 hours for the following week up till the following Thursday, when we felt like everything was fully excavated per Unitech. Unitech was the environmental people that we contracted with. They were very responsive. They worked with us all weekend, and we did everything in our power to mitigate our losses and to protect the environment. Was our goal. Worst week for me on Guam, I got to tell you that. So, that's all I can say about that.
So can I ask you to explain just a little bit then about what actually caused this spill and this solar?
Well, if you go into the Bison report, and we did, you know, this independent engineering firm did come out and go through the system
And you're talking about what's been marked here as Exhibit 3?
Yes, sir.
And I believe you all both have Exhibit 3, and this is a report that was done. Well, I'll let you explain it. What is Exhibit 3?
And if you go through it, you know, there's a lot of technical innuendos in here, a lot of things that talk about the fuel levels. You get down to, you know, basically to page 7 of this.
Let me pause you for 1 second, just to make sure we get that sort of entered.
All right, Exhibit 3 is the Bison report.
Correct.
We call it.
Yeah. And they are basically a fuel consultant, fuel management consultant.
Okay. So, any objection, Mr. Palazzo? Admitted.
All right, so if you could explain Exhibit 3.
Right, so basically we went through once the system was compromised, we locked out, tagged out the valves we just kept one tank running to provide steam and fuel to the building. We didn't let anything get touched prior to the Shields and Harper, which was our fuel management consultant, and the Bison group showing up with representative from Northern Lease and WWO.
In your own words, what happened? What caused the
Well, Well, and we've simulated this several times for the Navy to go to where we're at today. You know, the system has been turned over to the Navy. They are fully responsible for the system. Myself, I would not put the system back in auto. I believe there's still a design flaw. They're running the system in manual right now in their review and the design. These solenoids, however, I mean, they're an expensive piece of equipment, and they are designed for a fuel system. But one of the things that occurs is when the system is running at the different tanks. Well, the two new tanks run at a higher velocity than the existing tank, and everything is meeting the design criteria. For the existing tank, they actually have to replace the pump, and they may have done that already. The DZSP has to replace that. But what I believe, and this is just as my opinion, I've done several fuel systems. To me, it's over designed. It has pumps that aren't needed. The system runs at a higher pressure than probably is required. And this solenoid that failed is actually still in place, and it's fully operational.
But what does the solenoid actually do?
The solenoid that supposedly failed, I know in the report from EPA, the talk was that it appeared like the solenoid had failed, and it did appear that way. But during our testing, we found nothing wrong with the solenoid. So what we're seeing is when there's tanks running and the fuel pressure has a return, sometimes it can push that gate up that's not magnet. The way the solenoid works, it's a magnet, but it's a normally closed valve, and you can grab this valve and you can feel the gate in there loose. When the magnet energized, the gate opens. So, in my opinion, the fuel was pushing on it, and somehow, there was a surge or whatever, pushed this gate up, and fuel transferred out from tank 1 into tank 3. And if you go back through the advisory report and you look at the amount of fuel that transferred that night, it overfilled a full tank. These tanks are designed to hold. I want to say 95% of the capacity of the 20, so they're like, or it's 90%, whatever it's set up. And I apologize for not being technical enough to say that, whether it's 18,000 gallons or whatever. So there is safeties in place that allow some fuel to transfer, but there was just too much transfer of fuel. So to the point of, I think back in, I want to say it was May 23rd, we did a series of testing for the Navy. We witnessed it again. And this is just a random thing that happens. It's not, I can't sit there and say if we put it on auto today, that it's going to happen. It seems to be whatever's happening with the system that causes this gate, to occur. It could be, a boiler shutting off and it's not consuming fuel, and you have a surge of fuel hit this thing. I don't know. I'm not an expert on that. I just know that it was piped per the design documents. It was inspected through QC department, through NAPAC, and fully commissioned. And we went through two separate full commissioning processes. And one prior to the spill and one after the spill. And then we went through another series of tests because there were still some design things that the Navy added. We were directed to do those. We did them. And to me, the system is still not fully functional.
Can I ask you to explain the mitigation efforts, the cleanup after the spill? After
the spill, like I said, February 15th, came in that morning, 6:20 or whatever. Juan Patagli's my guy that was assigned to that boiler fuel system. And came over, we got lucky, we got Unitech out. Immediately, we took every spill device that we had, every spill device that WWO had prior to Unitech coming on site. We started sopping up everything we could get up, everything that had going into the earth. Once Unitech got there, we kind of outlined what we believe the perimeter of exposure was. Went through and painted basically markings on the ground of hey, this is where we're seeing the spill, and this is. So we went to the outlying areas and worked back to the spill. And started excavating the material. They brought out their cubic yard bags. We had guys going to every place on Guam we could get pallets. I think we collected during Saturday and Sunday. We collected 681 pallets, is what I recall the number was. From every place we could get them. We started filling bags up. Like I said, we didn't work around the clock because it wasn't safe to work at night because we didn't have all the lighting, or we would have. But we did work, every bit of daylight. When the sun came down off Nimitz Hill, we saved everything up, and that's what we did. So.
And can you just take a look at, I believe these photos were marked as Exhibit B previously by DEPA. And do any of these photos help illustrate what you're talking about for the mitigation?
Yeah, if you look at the first picture, you see the excavation along the perimeter road there.
I believe this was Exhibit B that was submitted earlier.
And that was kind of the outline of where the fuel went to.
Just wait a second for everybody to catch up with you. Yes. You're on the first page, right?
Yeah.
Okay, go ahead.
So on this page, you see kind of where it's excavated on that perimeter road, which was about to be paved the next day. I will say that on the following Monday. We started digging there. Now what you're not seeing is this road went away. We had to totally excavate the road also because fuel had got down below it and traveled through some existing ditch lines that were there. There was a water main down there that we had to get down to. We went down in excess of 14 feet in certain locations to get to what Unitech called safe, and I want to say it was below 25 parts per million for. And I'm not a cleanup guy. I'm just going. We followed their direction, but we being WWO and Dorman Lease, did all the excavating and all the earth removal to speed up the process.
Basically, you hauled away all the contaminated soil, correct?
We hauled it to Unitech where they had provided locations. And they were checking it in, they were checking it out. We basically bagged up 1,000 cubic yards of dirt in several days, and then we took off. I think it was on Tuesday the following week. We finally got approved to haul dirt in dump trucks to a burn site approved by Unitech. So we did that. I mean, it was quite the undertaking, and I think we demonstrated that we certainly we're trying to mitigate the problem. And
when you say a burn site, how is that? What does that mean?
That means that the dirt is burned to where all the fuel is burned out of it.
Basically evaporated away, is that?
I don't know
Maybe not
100% of the
evaporation.
process is burn out, but it's, I can tell you that nothing's cheap about any of it. We also, personally took a lot of, cost. Not saying it wasn't, it had to be done, and that's what we did. So, if you look through, you see the bags of dirt that we excavated, and right on back, and all the way back to where we refilled with clean fill, all back in. So.
Do you remember during the cleanup process, did DEPA indicate any concerns that the cleanup was not done correctly?
I'll be quite frank about that. Unitech dealt with that. Okay. I know that they did go through, and the Navy, EPA, and GEPA was out several times. I did sit in on the conversations, but really I'm not a professional when it came to that, and it was between them guys to basically mitigate that and work through all that process.
Anything else that you'd like to add regarding either the testing, commissioning process, any of it, to the cleanup itself? Anything else you'd like to add?
No, I mean, I know that the Unitech has, submitted the whatever the process is for putting the nitrates in the soil or whatever that's called. Yeah, the enzymes in, basically that's under the parking lot. You know, but everything that we could get to, we got to. I don't think there's any place that's not covered in concrete that we did not get to. I'm not saying that that's the right thing to do. I'm just saying that that's what we were advised to do, and that's what Unitech discussed with Guam EPA.
No further questions?
Any, Mr. Velazquez?
Yes, sir. Yes, I have several questions. How many pumps are there between the three tanks?
Well, there's 2 tanks on each tank, so there's 6 pumps on those tanks. Now, but that's not inclusive of all the pumps. So you have those supply pumps, and then at each generator, there's an additional 2 return tank pumps at each day tank, plus a pump that's on the day tank that goes to the generator. So you got 3, so there's another 9. And then when you get back to the boilers, there's an additional 2 return pumps. And then each boiler has its own pump. So in my opinion, I always suggest this, but I'm not an engineer. I feel like the whole system is over-designed as far as pumping.
Okay. And how many of these solenoid valves, at least to your knowledge, are there in this throughout the system?
This particular solenoid valve that's in question, there's 2 on each tank. Well, I'm just take that back. There's 3 on each tank. So you have, for each pump you have a solenoid, and for each return you have a solenoid. And it's a common return. So you have two pumps that ties into a common header, all coming off the tank, that have a solenoid. And then you have a return valve that goes back, a return that comes back. So 2 discharge, one return.
Okay. And you refer to this as a submittal document? Or submittal, I apologize, earlier?
Yes. This was in it, and I'd have to pull it back out, but in our fuel submittal packet, basically we submit all the valves, all the fittings, all the piping. You know, this has containment piping underground as well.
Okay.
And it's part of that package.
Okay. So then it was your company that submitted this?
That's
to
correct.
WWO to the Navy eventually?
Yeah, to meet the specification that was provided to us.
Okay. Was testing done on the pumps and the valves prior to the release? Was there
Yes.
any testing done?
Yes.
Were there any problems at that time?
Well, that's what occurred where we went through and added the other solenoids that was supposed to be the fix on the return.
Okay.
So yeah, in August, we seen that fuel was transferring to a tank that wasn't running, and which prompted us to write this RFI 1575.
Okay.
That basically said, hey, there's a design issue, what do you guys want to do?
Okay. When testing before the release was conducted, whatever parameters or I guess pressurization that was used as part of the testing process, were those the same parameters or pressurization limits that were in place when the release occurred? Or was there a higher pressurization at the time of the release than there was during the pre-release?
No, what we see, I mean, during testing, we tested 150 PSI per the specification.
Okay.
The system actually runs about 30 PSI.
Okay.
On the new pumps, on the existing pump, and what it's doing now, I don't know because I haven't been back on site this week, but the existing tank was running at about 11 PSI. And you know, we believe there was some sludge buildup or whatever. You know, that tank was, I think, 4 years old, you know, prior to us connecting to it.
In your opinion, could the overage of about 400% in pressurization, could that have led to the premature, I guess, breakdown of the valve itself?
I don't believe so. I mean, it's a rated valve. You know, the valves are rated at 105 PSI operational testing. You know, that valve actually, you know, was per the spec. You know, we tested properly. Those valves have a, you know, a system, you know, I think everything's designed to be tested and ran at 25% over working pressure. And what that puts you up to, I don't know. But I don't believe that there was any fatigue or any type of wear on the valve. It was a new valve. These new valves actually didn't see that pressure. We basically did per our inspection process, we did a in-use inspection. You know, basically, we turn it on and the system flows through it. So these specific return valves never seen that 150 psi.
Okay.
So they were added later, you know, per the Navy's direction.
Okay. Is it accurate to state that only one valve then, for lack of a better word, malfunctioned? Or was it
No.
multiple?
No, I can tell you right now that I've seen all three valves do the same thing that happened during the failure. You know, I don't think it's limited to one tank. I think it's a design issue. That is the wrong application for the wrong valve, in my opinion, just as Richard stated. I mean, you know, through discussions, you know, we can't, you know, we have to be careful about what we do as well, you know, as an installing contractor. We can say, hey, Mr. Owner, you know, you got the wrong valve here, but we can't tell you what to use. Or we become liable for the system. You know, we did have some verbal discussion about, hey, we need a positive shut-off valve. And when I say a positive shut-off valve, you know, I'm calling it a 2-inch. This is 2-inch pipe, a 2-inch ball valve with a motorized control, you know, on it, a motorized valve.
Mm-hmm.
So basically, it's a ball valve with 100% shut-off. That when that tank's not being used, it's turned off, and when that tank is being used, it opens back up and opens 100%. And the other valves fully lock out. That solenoid, the solenoids that are in place, and we've seen leak by not just on the return, but on the supply as well. You know, these are not, and if you go through, you know, these are not 100%. They're not anti-siphon valves, and that's what they want to kind of use them as. But we didn't have a siphoning issue. We had an overfill issue.
So I've got some questions.
Yes, sir.
Just to correct the issues, you know, during the initial inspection that we did up there, we spoke, and just to clarify, you mentioned that potentially it was the solenoid that was the problem.
Right, and
I just want.
yeah, I did.
Yes.
I absolutely did.
And, the other question I have is, you were operating the boilers when to pressurize the line and to
The boilers, you know, per the schedule that was discussed earlier, the boilers were started up in August.
So the boilers were operating 24/7 since August of 2013?
I don't know if it was 24/7, but they were functional. Yes, sir.
I just need clarification whether you were, it's no longer a startup issue. You were operating the boilers 24/7 to pressurize the line prior to occupancy of the hospital. Is that correct?
We had to provide
Yes or no?
existing systems, yes.
So you were operating the boilers without a permit from Guam EPA at that time? From what, October of last year to
Well, I
when the
think
spill occurred?
we did our paperwork to WWO. WWO did their paperwork. on that.
All I want to find out is
Yeah.
you were operating the boilers
But as you
almost
see-
24/7 to pressurize the line and to make sure that
Yes,
the
sir.
lines were since October.
We had to provide steam to the building. to make the
Understood,
building
but
functional.
there was no permit issued, an interim permit to operate this boiler. It's not a startup issue, it's an operational, when you do that. It's no longer startup.
If
Is
I
that
may,
correct?
You know, I'm just gonna object to the extent we're talking about, I don't know, permit violations and whether a permit.
I understand, it's not on the NOV,
Right.
but I just want to clarify that.
And I guess the
I mean-
purpose of this hearing is to focus on the violations in the NOV.
Understood. Just want to clarify that WWO was operating this boilers almost 24/7 since last year without a permit. I just want to note that.
And That's just argument, but we're obviously not prepared to address that today. That was not one of the violations that are
Understood.
issues.
I just wanted to be sure
Okay.
that we got it recorded.
I'd like to say one thing to that, even if I could. You know, we did Dorman Lease did our paperwork to WWO, that was turned in. WWO turned it in to NAPAC. NAPAC is the one to apply for the permit. WWO and Dorman Lease were contracted to NAPAC. We're taking direction from NAPAC. We got the green light. Everybody was fully turned on from NAPAC that we could operate the borders.
Understood.
Okay.
Okay, just to close out, you know, on this count, I mean, I'm not sure whether it's a design flaw as the respondents are alleging, or if it was just a dud in the valves that they received, or even the pumps themselves. But just for clarification, do I need to resubmit something that's already been submitted into evidence?
An exhibit?
An exhibit?
No.
No? Okay, then I just want to put on the record, point of reference, I do want to just reassert and just go back to the letter from the Navy dated, from Captain Heckman dated June 14, 2013. And again, just to read, WWO will be installing, testing, and commissioning air emissions units, ellipsis, as part of the U.S. Naval Hospital Replacement Project. WWO will assume responsibility for the construction, modification, or operation of the source in accordance with the Guam Air Pollution Control Standards and Regulations and any permit issued thereof during the period of performance of the project until the facility has been officially turned over. I just wanted to reassert that position.
And I guess I'll point out, that is a letter from the Navy to EPA, right?
Right.
That is not a submission from WWO directly. Correct? WWO did not assert those things that you're quoting. Captain Heckman asserted that, right?
Correct.
Okay.
Right. Oh, I did have another question. I noticed in the photos that there's no secondary containment around any of these tanks.
Absolutely, there's not.
Whose job was it to install that?
It's not part of the design documents.
It wasn't under any WWO?
Nope, it was questioned, and it's not a design, it was not required per the Navy.
Please remember, these are existing tanks, and existing tanks also.
Well, no, there were two tanks, there are two new ones installed.
Right, and the existing tank is on the same
Right.
pad, and it doesn't have a containment either.
Okay.
So these are containment tanks, I mean, they're double wall tanks. But you're right, there's no reservoir.
External secondary.
Absolutely, I wish the hell there was.
Under those 10%.
Damn right, I wish there was, it'd been a lot easier.
Okay.
But that's not the reservoir question, that's not one of the violations.
Oh, no, I was just asking. I wasn't trying to.
That's fine.
Okay.
That would've been nice.
You would have saved a lot of money.
Damn right it would.
Okay. No further questions?
No, sir.
Okay. Well, is it appropriate now to move to number 4?
Yes.
Okay.
And I believe, in fact, that most of the testimony given, in fact, specifically addresses 4 as well as 3. 4, if I can just quote from the notice of violation, the alleged violation, the statute cited is that it shall be unlawful for any person to store, collect, transport, process, or dispose of solid waste in such a manner as to degrade the environment, so on. Then the facts in support of that alleged violation, WWO failed to test the fuel safety devices on each boiler, causing the release of 2,000 gallons of diesel fuel. And so I would submit, based on the testimony given, that in fact there was extensive testing done, and in fact the factual violation of failure to test is not a statutory requirement. So the statute does not require any specific testing procedures or compliance. So the allegation does not support the statutory violation. Nonetheless, testing was done. And unless EPA has any evidence in support of this failure to test.
That was my next question. Does EPA wish to submit any quote refer to earlier evidence on this count?
I believe, sir, it's WWO's responsibility to make sure that all the safety equipment or safety devices on any of the equipment that they install is properly functional, and based on this, that wasn't certified. Therefore, whatever caused the release of the fuel is a solid waste issue, and they should rectify it. In addition, there's still contamination inside above the regulatory policy of Guam EPA, which the WWO hasn't remediated earlier.
So, is there any new evidence?
No, sir, there's no new evidence in this, and based on the, what has occurred, I believe it is the responsibility of WWO to make sure that everything is functional. And even though the Navy haven't accepted this until March of this year.
Okay, then does that complete the evidence? Do either party have any?
Not entirely, if I may. So what we've addressed so far are the alleged violations and the notice of violations. And then if you would turn to page 5 of the notice of violation of administrative penalty order section. In that administrative penalty order section, that lays out the actual dollar figures and how the actual dollar amounts were arrived at. And so we would like to address those briefly.
Okay. All right.
I guess I would leave it to people to go first on these as to their burden of proof to establish the $46,000 total.
Yes.
Administrative penalties, correct?
Yes.
Okay. Very well, then moving to the remedy requested, the penalty. Could you submit your support for or restate the amounts and submit your support from?
For the penalties?
Yeah.
Calculation.
The calculation is based on our matrices, Guam EPA's matrix, and every the violation for air pollution penalties are $10,000 for any violation, and that violation could go up and down, depending on how the matrix is derived for those. In addition, the same thing with solid waste violation. It's $1,000 per day for each violation, and depending on the matrix or how we go through the matrix for the fines, that's how we came out with an amount of $46,000.
Anything further on?
No, sir.
Okay.
Guam EPA, just to reiterate, Guam EPA has a set matrix for doing fines calculation. Same thing with US EPA, where they have some sort of matrix to calculate the amount, the penalty amount for any violation.
Is that a document, this matrix?
Yes, it's used by Guam EPA alone, and we don't provide it.
So it's not going to be provided today for this hearing?
No, sir. We don't provide that to any.
Well, in terms of then reliance on this matrix, which no one has seen, I would simply submit, of course, that is not sufficient evidence to justify any of the penalties. Just using the word matrix is not, of course, technically evidence.
Just to back up a little,
Yes.
if you look, the violation is for every solid waste violation is $1,000 per day per violation that we issue to WWO.
Oh, okay, let me address then the language here. In the air pollution violation section, it says the maximum administrative penalty for each unit of a new air pollution emission source is $10,000 per day per violation, or $30,000 for 1 day for the 3 boilers at the central utility plant.
Understood.
So
The errors in the 3 boilers should be 2.
Right.
Okay.
Does that agree?
Stand corrected.
Okay.
Should be 20,000.
So there's only 2 boilers, not
Yes, sir.
3? Okay.
Yes, sir.
So
That was corrected earlier when you mentioned it.
all right, so it can't be 30,000,
No, sir.
maximum 20,000, right?
Yes.
All right, so how did you arrive at 20,000 then, a maximum?
The maximum fine is $10,000
right.
times 2,000.
And what factors did you take into consideration in assessing the maximum as opposed to the minimum, or something in between?
We look at the type of the incident that occurred, and we believe it calls for a maximum penalty.
All right. Any particular factors that you can describe for the hearing officer?
Just the extent of the contamination that's at and the condition it is right now, that there is still contamination above.
And this violation here, this is in regards to the failure to provide, the alleged failure to provide notice on the
Right.
startup. This
Right.
has nothing to do with the spill, right?
Well, it relates back to the spill. If you didn't start it up and run the units.
But these are
for
boilers,
operation.
not the fuel tanks. These were noticed on the boilers, right?
Yes.
All right, so the boilers didn't cause the spill.
Yeah, the emission unit causes it.
The tanks, the fuel tanks are
No,
what?
the tanks did not cause a spill. If you didn't operate the boilers, there won't be a release. Understood?
Going back to the notice of violation, the violation for the fuel, for the boilers was that notice of startup was not provided, right?
Understood.
Okay.
So-
So then here you're saying because the spill was bad, this notice of violation or this failure to provide notice, it should be maximized. Is that your argument?
Actually, let me clarify. So the agency's policy is we assess the maximum allowable penalty per violation per
Okay,
day.
so you just start at the top.
Yes.
Okay.
And so what happens through the course of the resolution process is depending on what corrective action violators immediately take. You know, when a meeting, when a request to meet and possibly or discuss possible settlement is made, we take that into consideration. What did you do? I mean, do you admit to, you know, the error, whatever led to the violation? And then from there, there's a downward departure gradually of the assessed penalty. But automatically, we start at the very top.
All right. You start at the top because that's in a statute or a rule somewhere?
Yes.
What rule is that? It says it starts at the maximum.
No, it doesn't say you start on the maximum. but it
That's not
says
in the
that-
rule.
It's discretionary, but I'm authorized by law to assess the maximum.
All right. But you are required also to take into consideration a number of other factors, right?
Which we do.
Okay, and what were the other factors that were taken into consideration?
Well, again,
Because you didn't change it, it stayed at the maximum.
right.
Okay.
You see, that discussion happens during the possible settlement discussion. Okay, what did the company do to correct, you know, the error? What mitigation efforts did it undertake or cause to? That's when that comes into or is discussed.
And normally settlement discussions per se are not generally admissible here, and I'm not trying to go into the details of the settlement
I'm
discussion.
speaking generally.
Sure.
Yeah.
But, so there was some discussion, correct, between WWO and the agency along the lines of what you're talking about, right?
Correct.
All right. But you heard nothing, I guess, that convinced you to reduce?
Well, we didn't get that far.
Okay.
Just for the record, since you're asking, I would like to just state if that's okay.
Sure.
The reason we didn't get to that point was because when I had met with Mr. Mares and was one other gentleman, I don't recall his name right now. When I met with Mr. Mares and one other gentleman, we got as far as we shouldn't be held responsible for this, it should be the Navy. And at that point I said, okay, you know what, produce some documents that show what you're stating, that prove what you're stating. And we're gonna go back and we're gonna gather documents on our own as well, and then, you know, we'll see if we need to come back and continue possible settlement discussions.
Okay.
But that's why we didn't get to possible downward departure
Okay.
of the assessed penalty amount.
And there was in fact an actual petition for penalty adjustment downward submitted by WWO, correct?
I believe in its notice of defense,
Okay.
right?
Yes.
I think that's separate, right? The petition for penalty adjustment
That's
is
separate. That's
Okay.
what brought us here today.
So in terms of bringing it down, let alone, you know, having the violations waived entirely, that was submitted. I guess you just didn't have an opportunity to actually adjust downward, is that what you're saying?
We didn't have the opportunity to discuss possible downward departure.
All right. So basically, you start at the maximum, and normally you would consider other factors, but at this point, you just haven't. Correct?
Correct.
All right.
When it was issued, correct.
All right. Anything else as to this violation, the air pollution startup notice? Two others. Turning then to the solid waste violation. That's on the same page of the administrative penalty order. And I guess I would return to the agency and leave it to them to support the $16,000 penalty amount for the actual spill, right? The $16,000 is the
That's
spill.
from the date that the spill occurred to the date that we responded, and they start cleaning the site. That's 4 days.
Oh. So $16,000 total, correct?
4 violations.
All right. 4 violations for 4 days. Can you explain what are the 4 violations?
The 4 violations that's listed on the sheet.
Okay, so it's based on 2, 3, and 4. And I think we agreed also that number 2, in fact, just refers to 3 and 4. Number 2 says, unlawful to violate any provision of any rule, regulation, standard, or order. So number 2 is not a separate violation in and of itself. Number 2 just refers to the code, all the rules and regs, 3 and 4.
But you still violate the code of rules and
But you're basically counting it
I think,
twice, right?
okay, I think I know what you're getting at. So basically, number 2 encompasses numbers 3 and 4.
Right.
Okay, I understand.
Is that correct? Would you agree with that?
Let me
Sure.
read.
I would have answered that.
So then it should be two.
No,
I would have answered that.
I don't think so. If it is encompassing that, then it should be combined.
Okay, I understand what you're saying. I will not, though, agree to your position.
No problem.
And that is because previous cases that the agency has been involved in is we
Done it this way
separated them.
before.
Correct.
Okay. So, again, starting out with the 4 alleged violations for 4 days, one of them is based on that number 2. The first violation, if you will, was based on number 1.
Understood.
So you counted that one twice also, right?
I stand corrected on
No
that.
problem.
So it should be only 3,
Okay.
like $12,000.
Maximum of 3.
Yes.
So then the 2 remaining were the numbers 3 and 4, where WWO was alleged to have allowed the solid waste to be placed on the property and the failure to test, right?
Yes.
All right. And the failure to test, you didn't have any actual affirmative evidence that they didn't test, right? Just the fact that it failed.
Well, during the initial inspection, there was some,
That there was no testing?
well, during the investigation process, during
Okay.
this initial.
That's just based on what you understood Mr. Gates to say?
Yes, sir.
Okay.
Yes, everything here is based on the initial investigation.
Okay. And let me just ask you also here, when you write, the administrator has used the statutory factors in assessing the amount of the penalty. The factors include, but are not limited to, the nature and history of these and prior violations. So you took that into consideration in assessing the $16,000, or I guess we would say $12,000.
Yes, sir.
So the history of these and prior violations. What was the history of prior violations?
Okay. Again, just to go back to what I stated earlier, we didn't get to that point
Okay.
in the possible settlement discussions. What we do as an agency, the policy is for first-time violators. This is when we get to that point. We automatically reduce by 50% the assessed penalty amount right off the bat. That's for first-time violators.
Yes.
And then we continue working downward from there. But again, we never got to that point.
Okay. So WWO is a first-time violator in regards to all of these, is that correct?
As far as environmental issues, yes.
Okay. No other violations that you're aware of?
Not that I know of right now.
We would have gotten to that point.
And any particular concerns or problems with the corrective action taken? Did you see any defects?
Well, as far as the corrective action and as far as the final submittal that was submitted by Unity, there is still some corrective action that needs to be done. In particular, they need to delineate the extent of the contamination that's currently there.
All right, delineate the extent, that means show how far?
How far down the contamination
All
is.
right, so then
And
maybe additional corrective action would be required?
Yes, there is.
Or maybe not?
No, there is.
Oh, okay, what is the additional corrective
Well,
action?
first, we need to find out how far the contamination is.
Okay.
And we don't know how far down that is.
So additional corrective action is not
It's
for
possible.
sure?
It's possible.
Okay,
We believe will be necessary.
okay. But have they not done anything that?
They have done, a lot to remove the contaminated soil, but there is still contaminated soil, it's like, to the limit of, I think, between 350 to 6,000 ppm at the site. And those particular sites, we need to know how far down is that contamination.
So have you issued something to either?
We haven't issued the stuff, a letter to them regarding the report that was submitted and their recommendation, but that letter will be forthcoming.
Okay, so they've complied with everything you've issued so far?
As far as, yes.
Okay, so in terms of mitigation, they've basically done everything that they could according to what
No.
you've required?
No, for now, we still have to review the documents that were submitted, and they need additional corrective action.
Understood, in the future, there may be something issued?
Yes.
But that's not part of this?
It's not part of this.
Okay. So they've done all the mitigation that was required of them. There are no prior violations of any nature, correct? No other violations?
Not to my knowledge.
Any other factors that you took into consideration in assessing these violations?
I don't think so.
You know, you did base the solid waste violation, 4 violations on 4 days. We talked about really 2 to 3 violations. So 4 days, where did you come up with?
Sorry, for Friday, I think the incident occurred on Friday until Monday of that day.
Okay.
Understood.
Completion
Okay.
date.
So you're alleging the fact that it was in the ground as sort of a new day of violation?
Right. It still existed.
All right. And is that actually based in any of the statutes where it says, the spill occurs 1 day, but the fact that it's on the ground the next 3 days means 4 days of violation? Is that in the statute or?
Every day is a succeeding violation so long as the contamination
It's
exists.
still there.
No problem. And is there a specific statute that?
It's per day,
specifies that?
per violation.
Right.
I'm sorry, is there a specific statute that says every day that it's on the ground? What statute is that?
I mean, it
Is it
states
cited
that
in
for any
there?
violation, it's a per day issue.
Was it cited in your order?
Yes, I think so. Page 2, the 4th paragraph.
Of the notice of violation.
I see what you're referring to. 51115B.
That's correct.
It says for each violation or non-compliance, right?
Yeah.
So it doesn't say each day. It says for each violation.
Per day. Take a look at that.
$1,000 per day. I see what you're
Per
saying.
violation.
Per violation.
All right. So if there was a spill on 4 days, how would you calculate that?
4 days.
4 days.
Okay.
$1,000.
And if there was a spill on
3
1
days.
day,
Oh, it's
1
3
day.
days.
it would
Well,
be the same.
3 violations.
If there was a spill on 4 days, how many days of violation?
Pardon?
If there was a spill on 4 days,
For the 3 violations that occurred.
I'm saying for 4 days of spilling on each day, how many days of
That's,
violation?
the spill is still existing. It's not cleaned up.
4 days.
Right.
So a spill on 1 day, how many days of violation?
Well, it depends on how long it takes to clean it up, because it's present in the environment.
Right. So you would assess it the same regardless? of-
Absolutely.
So the spill really has nothing to do with it, it's how long it's in the ground, you're saying?
Yes.
If we could ask for a 5-minute recess before we ideally conclude?
Yes, so we'll take a 5-minute recess.
Yes.
Okay, we're back on the record. Where are we at? You had more argument or question?
Assuming there is nothing further from DEPA, we would rest.
Anything further from DEPA?
I would just like to go back, if I could, I believe to an exhibit that was submitted as part of count 1, which is enclosure 8.
Yes.
Enclosure 8?
Yes, Ron. It was this color coded.
Oh, well, let's see, that's the,
Yes, Bill?
which one was that?
Exhibit number?
It's exhibit number 7.
7.
7.
You proceed.
Okay. When was this submitted to NAFTAC?
That gets submitted every month that we're in construction. So this particular one, if it's August activity, it would have been submitted the following month in September, and then again October, November, December. It becomes part of the permit record.
Just ask you if you take a look at
That's a run date.
Here, about to fall off.
That's a record.
Print, that's just a print.
Are you referring to the bottom right-hand corner as the print date?
He's looking at, he asked me about the top left-hand corner.
Okay.
Bottom, he pulled it out of the schedule dated April 26, 2014.
Okay.
But we do see the letter A after the date? This is AM and then A, PM and then A. Our next column over. See how we have the date and the time, and then there's the letter A, and then over here there's the PM activity and the letter A. The letter A only appears once it becomes an actual. So this is these are actualized dates, meaning these are the record dates for these activities.
Okay.
And that gets, this is one page of about a 50-page or 75-page report that goes to NAFAC every month.
Okay.
And it becomes a record document. It's the schedule.
Okay.
It's the living schedule.
Okay, then I'm curious to know how this could have been included as enclosure 8 as reference on Captain Heckman's letter.
That wasn't included on Captain Heckman's letter.
But it was cited as enclosure 8.
Well, enclosure 8 is a separate document, right?
I know what you're saying. If you don't mind me coming over.
Sure.
Enclosure 8 is this one. Enclosure 8. And here's the proposed testing dates.
Okay, but then
That's
earlier,
a separate, that's a
correct, but
separate.
earlier you referenced this as having met the 60-day requirement
That was the
based on
actual
this date.
startup.
So are we referencing this or this?
That is the notice to GEPA.
Right.
So that is an address, that answer.
What is that? Exhibit?
That is exhibit 7, I believe.
Those are projected dates, those are actual dates.
Sorry. Is exhibit 7, is that the captain? Exhibit 6, I apologize. So Exhibit 6
Is Captain Hickman's
is
letter?
Captain Hickman's letter.
Okay.
You have that, Mr. Hearing Officer? Exhibit 6. All right, and the enclosure 8, the very last page of that exhibit, indicated a proposed startup date. And that's what it says, proposed startup date.
Okay.
So that was notice to GEPA of the proposed startup date. That was in response to that first violation, that no notice of the startup date was given. So that was the notice to GEPA, the proposed startup date. Yes, that's before the actual startup. That's the notice, right?
Okay.
All right, and so then the other exhibit, when the question was raised, well, when did it actually start? Well, that was this exhibit, which was perhaps 7, which then answered the actual startup date. So notice was given prior, less than 60 days prior to the actual start.
Less than 60 days.
Correct. From June 13th on the stamp receipt letter from GEPA. June 14th to August 12th. June 14th to August 12th. A hearing officer can take judicial notice of however many days that is actually. I believe it to be less than 60.
June 14 to August 12?
Yes.
Yeah, that's
59.
59 days.
So less than 60 days, which I believe is even required.
Of course, I don't know about this, what's included.
Even if you added a day, I think they're still within the 60
Include
days.
end date, in fact. Yeah, the end date's excluded.
Anyway, did that answer the question? Sorry,
Okay, I just wanted to make sure
yes.
or clarify which one actually you're referring to as
Yes.
far as startup date.
Correct.
Okay.
So, for instance, and it appears we did notify you. Would you be willing to withdraw that piece of the violation?
We as in WWO?
You as in CEPA, would you be willing to withdraw that part of the violation since you have in your hands that we did notify you?
You're saying WWO notified Guam EPA?
We're saying notice was given, WWO gives it to the Navy and NAFTAC provides it to people, yes. Mr. Hearing Officer, can I just make sure also that Exhibit 3 is admitted into evidence, that's the Bison report? I believe you have that. Yeah, that's one, It's going to be a thicker.
And there will be $10,000 from August.
Exhibit 3 is admitted.
Okay. And you actually have a physical copy of that?
You can.
Yes.
Even you should not have it.
Okay.
And then we can double that.
So,
Okay.
you're saying Exhibit 7
You can tell
was
me.
actual notice to keep them?
Yes.
And show it.
And
I'll not pay
so
for
you-
each, nothing.
Keep received it.
They have it stamped on the front page.
Do I have that, a stamp receipt?
Yes.
I don't, do I?
The June 14th letter, which is a little bit thicker. Nope.
That's all I
The
have.
next one, the next one. That right there.
Oh, Exhibit 6.
6.
Yes.
6.
That's the actual notice.
This is an exhibit.
And the enclosure number, the last page, enclosure 8, the very last page. That's got that proposed startup date, the last 2 lines.
Proposed, but
That's the notice of the proposed startup date. That's what they were alleged not to have given. The violation was failure to provide notice of the proposed startup date.
this is the actual startup date.
The other exhibit was the actual. Of course, that occurs after, right? They give them notice, this is when we intend to start.
But you started later?
Correct. But those were given in advance, and the actual startup date was proposed. So there was still notice.
No, I just need clarification, because I was of the impression, and I'll admit that it was not accurate, that this was enclosure rate, and I was gonna ask, how could anyone have known on June
Right.
start and end times in August? So, yeah, we're willing to strike that count.
Okay. So that would be the first violation, as I understand,
Correct.
of that notice of violation.
We're willing to remove that.
So noted. Let it be so then.
That was the $30,000, alleged $30,000 penalty, right?
Right. Well, 20, right?
Well, yes, and then
Yeah.
reduced to 20.
Okay.
Thank you.
You're welcome.
All right, so are we ready to conclude or almost there?
We have nothing further.
Okay, I've got everyone satisfied that all the exhibits that each party wants is in. I've got A, B, and C from EPA and 1, and 6, 7, 2, 3, and 1 from the respondent. That's the record,
Yes.
besides the testimonials.
I apologize, Your Honor. Just to confirm, is respondent's exhibit 6 also submitted as one of EPA's exhibits? As I've
No,
referenced it twice?
as respondent's exhibit.
Okay.
The exhibit 6 is WWO's exhibit.
Correct. Okay, but because we also reference it at least twice in our testimony.
That's fine.
Okay, okay, thank you.
Okay, well,
So what's in the balance here is
6,000.
12,000.
12,000.
12,000 what's in the balance.
right, well, I'm gonna take it under advisement. I'll write a proposed decision and submit it to the board. They make the final decision. In the statute, it says that the decision that I submit to the board is a public record, yet it does not say that I submit it to the respondent or EPA. You won't be getting a copy.
If that's how you read it, I mean, in the end, it's what they issue that will control anyway.
And then the board can adopt my decision in its entirety. If my decision should find a violation and propose a penalty, the agency may accept the amount or reduce it. It may reject my proposed decision and do one of two things: decide the case upon the record without or with taking additional evidence. In either case, the parties, EPA and WWO, can present oral argument to the agency. I guess you'll get notice. Or you can refer the case back to me or to another hearing officer and direct the taking of additional evidence and the preparation of a proposed decision. So you can read the statute and analyze it for your plan, and the best way I read it.
Sir, I just want to get one clarification from WWO. So the boilers were started in August 12, 2013, and it became operational from there on? I just,
Not sure at this point.
based on the start off
Right.
on your schedule, was it from there and you started pressurizing the system from there on, and the boilers were operating 24/7 from there on? Is
I
that
think I
correct?
understand the question. I'm not sure that it directly relates to that.
I understand, but I want just one clarification,
That's
whether,
right.
okay,
August 12th.
understood.
Thank you, Your Honor.
Okay, the date's June 24th, now, time is now 12:10, and we are adjourned.
Thank you.